of India has pronounced one judgment on 8th of July 2024. It's a criminal appeal number of 2024, arising out from the special leave petition criminal number 6339 to 6340 of 2023. And it's Appellant versus the Narcotics Control Bureau and others. This is the case title here. So, Honorable Supreme Court of India has means they have deleted two conditions which were imposed by the Honorable High Court, and which the two conditions were imposed. Number one is the obtaining a certificate from the Embassy High Commission, and second is the dropping a pin of the Google map. The court has interpreted the provisions of the Code of Criminal Procedure. There is Section 439, 437 subpart 3, and Section 37 of NDPS Act. Finally, the court has held that the court which granted the bail to the appellant cannot impose an arbitrary, fanciful, or any condition which extend beyond the provisions of CRPC. In short, they can't impose the freakish conditions while granting the bail. That it violates the fundamental rights of the accused, and as far as the criminal jurisprudence is concerned, every accused is presumed to be an innocent till proven guilty by the law. So, imposing such freakish conditions that he had to drop a pin of the Google map so that his movement at the real time can be located by the investigating agencies. The court has said no fruitful purpose will be solved except it leads to the violation of the fundamental rights. Let's now comes to the judgment, deeper into the contents of the judgment, and we will analyze, we will discuss the major portions which Honorable Supreme Court have interpreted the law, in what manner they have interpreted the law. The paragraph number 2 says that appellant is being prosecuted punishable under Section 8, 12, 23 and 29 of NDPS Act, and the appellant was arrested on 21st of May 2014, and by the impinged order dated 31st May 2022, the appellant was enlarged on bail. So means appellant was arrested and he was granted a bail on 31st of May 2022, subject to the various terms and conditions incorporated in the orders. Means the order has certain conditions while granting the bail. So that order is challenged by the appellant before this Honorable Supreme Court of India. The terms and the condition incorporated in that by this court in paragraph number 15 of its decision in the case Supreme Court Legal Aid Committee representing under trial prisoners versus Union of India. The appellant was ordered to be enlarged on bail on furnishing a bail bond in the sum of rupees 1 lakh with 2 surety, like to the satisfaction of the learned special judge under the NDPS Act. The grievance in this appeal has been summed up by this order dated 21st July 2023 passed by this court, which reads as: the petitioner is aggrieved by the following condition imposed while granting the bail. Means the special judge shall ensure that certificate of assurance from the High Commission of Nigeria is placed on record that appellants accused shall not leave this country and and shall appear before this learned special judge as and when required, and the complaint filed by the Narcotics Bureau of the NDPS Act indicates that the appellants are the residents of the Nigeria. So in the case of the Supreme Court Legal Aid Committee versus Union of India, the clause that judgment in which the clause 4 read as that in the case of the under trial accused who are the foreigners, the special judge shall, besides impounding the passports, insist on the certificate assurance from the Embassy High Court of the High Commission of the country to which the foreigners accused belongs, that the said accused shall not leave this country and shall appear before these special court as and when required. Prima facie, we are of the view that none of the Embassy High Commissions may be able to give assurance as mentioned in clause 4. The question is whether we need to refer this case to the larger bench for reconsideration of the clause 4. Another condition imposed by the high courts was that they shall drop a pin on the Google map to ensure that their location is available to the investigating officer of the case. And now there are two questions are raised: whether they should refer to the larger bench as per the condition imposed in the clause 4, and second question is whether this condition will afford means offend the right of the accused under Article 21 of the Constitution of India. This was the condition which was imposed. So they appointed two amicus curiae, means to on both the issues, and means that they listed the matter. They have court has gone through the previous orders on the connected matters. So they now the amicus curiae was appointed, and now court has interpreted the section 439 of CRPC, which says special power of the courts or the court of sessions while granting the bail. These were the provisions that were mentioned in the Code of Criminal Procedure, and means for section 439 says that any person accused of the offence is in custody shall be released on bail if the offence is of nature specified in subsection 3 of section 437 may impose any conditions which is considered necessary for the purposes mentioned subsection. So means sections 439 subpart A says that court means High Court or the Session Court may means direct a person who while granting the bail they shall direct a person and impose the condition which were mentioned in section 437 subpart 3, and the court may means the condition may be modified or set aside provided that there is a provision is there that means if the condition if it is trial by the punishment with the imprisonment for the life. So it means condition the provision can be the provision says that the conditions can be altered, can be set aside or modified as per the these legislation says. And 437 subpart 3 says when a bail may be taken in case of non-bailable offence, and these were the conditions there. 437 subpart 3 that means whether when a person accused or suspected of the commission of the offence punishable with the imprisonment which may extend to 7 years under chapters so and so of Indian Penal Code or abatement of consequence, that person shall attend in accordance with the conditions and of the bond executed under this chapter. And so the section 437(3) subpart says that these were the conditions which normally the trial court or the means which the court of High Court or the court of sessions generally imposed while granting the bail. So these were the conditions there that he shall means attend in accordance with the conditions to bond. Means every person have to furnish a bond. There were the conditions that he should not means certain conditions are there. He should attend the court proceedings regularly. He should not means will commit any similar offence or which or shall not threaten to the witnesses. These were the conditions generally imposed on the accused. Or I shall not induce the witness, or I shall not means not run away from the country. These are the conditions which generally been imposed. And now says the provision related to bail contained in section 37 of NDPS Act. These are the contents of the section 37 of NDPS is reproduced here in the judgment. That is the offences to be cautionable and non-bailable. So while granting the bail, means he will have to give an opportunity to the public prosecutor to oppose the bail application. He has to satisfy the court that they are the reasonable grounds of believing that he is not guilty of the offence. He will have to convince the court that he is not guilty of this offence. And section 37 of the NDPS Act says. So the reason is because of section 52 of the NDPS Act, the provision of CRPC applies in the arrest made under NDPS Act and so are not inconsistent with the NDPS Act. So it says that provision of CRPC is applicable. In case there is inconsistencies there, then provision of CRPC may not be applicable, but generally if it is means the legislation says section 52 of NDPS Act says that the provision of the Code of Criminal Procedure is applicable. So these are the conditions, and now they have cited a judgment, Kunal Kumar Tiwari versus State of Bihar. So they have highlighted this paragraph that the court can impose a condition, but it cannot be arbitrary, fanciful, or extend beyond the ends of the provision. So in the interest of the justice, or clause C of means good administration of justice on advancing trial process. So these are the conditions court can impose, but it should not be arbitrary. And 438(2) subpart 4 of CRPC This relates to the means while granting the anticipatory bail, and that says that there is another judgment is there, Munish Bashir versus State of NCT of Delhi, and the contents of the paragraph number 10 of the judgment is reproduced here, that neither the High Court nor the Court of Session would be justified in imposing the freakish conditions. So means while enlarging the bail, they should not impose such freakish conditions or arbitrary conditions. It should not be fanciful, it should not be arbitrary, it should not be freakish. So the court can impose conditions, but it should not be interfere or obstruct the investigation in any manner. Or means these are the conditions they can impose, but why they have cannot be imposed? So then the court has made a reference to another judgment which was passed by the Honorable Supreme Court, that is State of Andhra Pradesh, which is Challa Ramakrishna Reddy, and the paragraph number 22 says the right to life is the basic fundamental right. It's guaranteed to every person by the Article 21 of the Constitution, and shall not even state has the authority to violate the right. A prisoner, he is a convict or under trial or detention, does not cease to be a human being. It says whether he's a prisoner, whether he's a detention, but first of all, he would have to see that he is a human being. So even when they're lodged in jail, he continues to enjoy all the fundamental rights, including the right to the life guarantee to him under the Constitution. On being convicted of the crime and deprived of the liberty in accordance with the procedure established in law, prisoner still has to be retain the residue of the constitutional rights. Court says even if he gets convicted, then again he will have to enjoy all the fundamental rights while being there in the lockup or in the jail. Means right to life is the main fundamental right. So the reasonable restrictions may have been imposed, but he can't be deprived of the life. So these were the conditions. So they have cited a judgment. Now they have interpreted it while dealing with the case accused whose guilty is yet to be established. Now court has interpreted this section that maybe appellant still not have been convicted. He's just he's just facing the trial. So he has not been been convicted. So he's not a guilty. Now still he's not guilty. The presumption of innocence is applicable here. He can't be deprived of these rights granted under the Article 21 of the Constitution, and court may impose certain conditions while granting the bail. And bail up now court says the bail conditions cannot be so onerous or to frustrate the order of the bail itself. Means court can grant the conditions of the bail, but it should not be so much fanciful or so much arbitrary that it will frustrate the whole order. For example, the court may impose the conditions of periodically reporting to the police station or not traveling abroad without a prior permission. Where circumstances require, the court may impose the conditions restraining the accused from entering a particular area to protect the protection witness of it. So the court says these are the genuine conditions they can impose. That he should not leave the country, he should not come into the area, he should not threaten the witnesses or come to that area where the witnesses are living or so on. So these are the conditions, these are the reasonable conditions. And but the court cannot impose the conditions that accused to keep the police constantly informed about his movement from one place to another. The object of the bail conditions cannot be to keep a constant vigil on the movements of the accused in last of the bail. The court says that these are the conditions which violates the fundamental right. He can't be informed. He can't constantly informed about his movement. Means a constant vigil to the police, where he's been going, where he's been residing, so where he's going. So these are the conditions he can't be imposed because this violates his fundamental right. The investigating agency cannot be permitted to continuously peep into the private life of the accused in laws on bail by imposing arbitrary conditions. Since it violates the right of the privacy of the accused as guaranteed by Article 21, if the constant vigil is kept on every movement of the accused in laws on bail by using of technology or otherwise, it will infringe the right of the accused guaranteed under Article 21, including the right to the privacy. The court says it will violate the privacy if he constantly says that about his movement, he's constantly kept under the scanner, it violates the fundamental right. Subsection 2 of 441 of CRPC, the court has now made a reference to that section. The conditions imposed by the court while granting the bail is always stands incorporated by the bail bond executed by the accused. Therefore, accused is bound to by the condition imposed while granting bail. If accused, after being enlarged on the bail, committed a breach of bail conditions or commit any offence, the court shall have the power to cancel the bail. So section 441 now may make a reference to the section 441 subpart 2 that court can impose conditions. If he made a breach of those conditions, court has the every right to cancel his bail. So court in its discretion can cancel the bail if the accused has made a violation of the terms and conditions as specified in the bail order. So conditions cannot be imposed while granting a bail which is impossible for the accused to comply with. If condition is imposed, that will deprive the accused of the bail, though he is otherwise entitled. Court says, if the conditions are imposed, then definitely it will deprive the accused of the bail. Otherwise, he is entitled to the bail. So, court in short says that conditions should not be fanciful, should not be arbitrary. The conditions should be imposed, but it should be reasonable and depending upon the facts and circumstances of the case. So now they have made an analysis condition on dropping of the pin on the Google Map. They have issued the notices, and the authorized person from the Google had filed and tendered an affidavit, who is the authorized signature of the Google LLC, filed an affidavit. It says that means code means they as soon as a person imposes means drop a pin on the location choosing the map. Dropping a pin means allow user to mark or identify a location on the map without necessarily requiring access to the user's location data. It means code has made an analysis that even the pin is to be dropped, then again the very purpose of granting the bail cannot be solved because the real-time tracking cannot be made out. The pinned location does not enable the real-time tracking of the user or the device. So the court says, the affidavit says of the Google LLC says the user had the full control of the sharing the pin with other user, but it does not impinge on the user's privacy. Most importantly, the pin location does not enable the real-time tracking. The court says they are imposing the condition that real-time tracking can be done. On the other side, the Google, the LLC have filed tender affidavit. It says that real-time tracking cannot be. They can't be. Pin location does not enable the real-time tracking. So the condition imposed, dropping a pin as stands, is completely redundant, and same does not help the first respondent. The court says this, even the condition is to be complied. Then again, these conditions make them makes the means it's completely redundant, as it does not help the first respondent. So these conditions which imposes the police investigation to track every movement, court has said is undoubtedly violates the right to the privacy guaranteed in the Article 21. So after detailed analysis and after making an analysis, the court has finally deleted the conditions which were imposed on the appellant. So these conditions were deleted, including the dropping of a pin of the Google Map. So this judgment was pronounced on 8th of July 2024.
उम्मीद है कि यह वीडियो आपको पसंद आया होगा। अगर आपने अभी तक हमारे चैनल को सब्सक्राइब नहीं किया है तो कृपया इसे सब्सक्राइब कर ले और बेल आइकन दबाकर नोटिफिकेशन प्राप्त करें ताकि आप हमारे नए वीडियो से अपडेट रह सकें। अगर आपको यह वीडियो पसंद आया हो तो कृपया लाइक करें और अपने दोस्तों के साथ शेयर करें। हमारे चैनल पर आपको न्यायिक मुद्दों, कानूनी सलाह और कानूनी अपडेट्स के बारे में नवाचारिक और महत्वपूर्ण जानकारी मिलेगी। हमारे साथ बने रहें, क्योंकि योगेश महाजन लीगल आपके कानूनी सवालों का सहायक है।